Hello, everyone, and welcome to this webinar on behalf of Wilberforce Chambers, addressing a career at the Chancery Bar for women. My name is Marcia Shekerdemian, and I'm here with my colleagues, Littler and James McCreath. And what's our objective? Our objective really is to encourage you to pursue a career at the Chancery Bar, a fantastic career for women. And as far as the structure of this session is concerned, it's really an open floor to you, our participants, to take this opportunity to ask us all the questions that you would like to ask us. The floor is yours using the Q&A function on Zoom, not the chat function. I think we've disabled the chat function anyway. So what we're going to do is just kick off with famous last words, a few words from all of us, bearing in mind that we are barristers, we like to talk and we're paid to talk. So I'm not committing to quite how few the few words are going to be. But as I say, once we have finished talking, it's for you, it's a free-for-all to ask us whatever questions it is that you have bubbling up inside. A little bit about us to start off with. I was called to the bar in 1987. I'm 58 years old. I took silk in 2015. My practice is quite a specialist one, pretty much nothing but insolvency and company work. I sit as a deputy insolvency and companies court judge. I've got a particular interest in equality and inclusion. I was chair of the Chancery Bar Association E&D subcommittee from 2016 to 2019. And it was in that role that I researched and authored a report which was published just over a year ago called Voices of Women at the Chancery Bar. Anna was called to the bar in 2009. Her practice, it covers commercial work, fraud, arbitration, insolvency work, company work. And she's done a fair amount of offshore work, which is, as we'll come on to, a feature of Chancery work. James was called in 2009. His practice covers commercial work, fraud, property, pensions and trusts. He does a bit of insolvency and a bit of company, but not as much as Anna and I do. So what is Chancery work? Well, you'll have gathered from my description of our practice profiles that Chancery work covers an enormously wide spectrum. And what it isn't is a narrow, dust-covered Dickensian practice area where we are all firmly stuck in the 19th century. So we've got commercial work, we've got arbitration, we've got international work, a lot of offshore work in jurisdictions like the British Virgin Islands, Bermuda, the Cayman Islands, Nevis, property work, company work, pensions, trusts, probate, private client, intellectual property and tax. And here at Wilberforce, we cover all of those areas, apart from intellectual property, which is a specialist area. There are only 2 or 3 sets that do it, and they tend to be stuffed with people with science degrees, which is a prerequisite if you want to do any kind of patents work. We don't do that much hardcore tax. But other than that, we cover the whole gamut of Chancery work, and crucially, we cover work that is, as far as the outside world concerned, is commercial work with a capital C. But as far as we're concerned, it's commercial work that all Chancery commercial sets will do. So we're looking at international arbitration, you're looking at insurance litigation, you're looking at international sales, you're looking at banking, you're looking at finance, you're looking at civil fraud, all of those practice areas that come under the umbrella of commercial work, we do. And what about the bar as a career for women? Well, the civil bar, I can say, obviously from personal experience and from the experience of all the women that I've come to know and work with over the last 30 years in practice, is a great career for women. It gives you the flexibility that a self-employed practice will give you. It gives you scope for flexible working. And in a well-run set like Wilberforce, you will find yourself practicing in a supportive and collegiate environment where your colleagues and your clerks want you to succeed. So in a set like Wilberforce, there will be, from the moment you come in as a pupil, a focus on the development of your future career. And once you are in practice, once you are taken on, you can be quite confident that you will have the benefit of our fair allocation of work policy, our practice development team, which will make sure that you as a woman are given as much opportunity as your male contemporaries. So there is every motivation to make sure that your practice is the practice that you want it to be and is as good a practice as you can have. So I'm going to now hand over to Anna, who is going to tell us, give you her thoughts on why a chancery practice.
Hi everyone. So thank you, Marcia, for the introduction. So as Marcia has just said, I'm going to talk about why I think chancery and commercial chancery work is an excellent choice, not just for women, but actually in general. And one of the main positive elements that I see from a chancery practice is, as Marcia has just mentioned, there is a great breadth of different practice areas. So when you come to a set like Wilberforce, when you start out, you'll be given exposure to pensions, trusts, property, straight commercial work, whether it's contractual work, civil fraud, company insolvency, so many different interesting areas. And so you don't have to try and decide on the basis of your academic experience. And most people coming to the bar, we have some transferring lawyers who have a lot of experience of the law in practice, but most people, it will either be a second career coming from something totally different or people coming from study. And it isn't easy, at least from my experience, it isn't always easy to know exactly how the subjects that you've studied academically translate into day-to-day practice and what will be involved. And so having the option to keep that exposure very broad at the beginning and see what each practice area involves on the ground. For example, the balance between court work and paperwork, the balance between being led by a silk and doing work on your own. All of these things can be quite specific to different practice areas, and there are different balances in them. And so from my point of view, it was really good for my first few years of practice to just find my feet, knowing what I enjoyed and what sort of life work balance I wanted to have and paperwork court balance I wanted to have. In terms of the different areas, there are also within Chancery, as Marcia said, we do the hard-hitting commercial work. So in my commercial practice, I'm almost inevitably against or working with barristers at the straight commercial sets. And then right at the other end of the spectrum, I've got private client trust work, where I'm learning all about families and whatever problems or disputes they might have. So you've got lots of different working practices. You've got the human interest at one end of the spectrum. You've got big international disputes at the other end of the spectrum. And in a set like Wilberforce, as Marcia has also alluded to, you have a lot of interaction with your clerks throughout your career. You have 6 monthly formal reviews with them, but also you can pick up the phone or go and see them whenever you like, to chat about the direction that you want your practice to go in based on the experience that you're having. And that, I think, is one of the major pluses of Chancery work and being in a good, well-organised set, in that you have the scope to really shape your career, having had some experience deciding what it is you really enjoy doing. From the perspective of a woman, although I actually think it's equally applicable to men in many ways, the other great thing about Chancery work is because you've got all these different areas that give rise to different day-to-day balances. If you get to a time in life where you really want more flexibility, or you decide that you want to work part-time. So for example, I've got 2 young children. I don't work part-time, but friends of mine at the Chancery Bar who have had children have sometimes wanted to come back, reduce their workload. And so when it's a time in your life where it's really important to get that balance right, having that flexibility, I think is really important, and I think is one of the great pluses of the Chancery Bar. The other thing is that in a good quality set with good quality Chancery work, we're very lucky in that it's well paid enough that if, and I'm thinking of children again here, if you have children, you are able to at least afford to have flexible wraparound childcare, so that on weeks where you do have a heavier workload, you're not worried about what's going on at home. But equally, I still make sure that I build in a lot of time that I'm at home when I need to be and when I want to be, as much as I possibly can. So those are a few of the reasons why I think being at the Chancery Bar is a great career generally, and a great career for women. But when I spoke to some more junior colleagues who are women, and friends at other sets who are more junior and so have been applying to the bar more recently than me, I wanted to make sure that the questions that I may have had when I was applying for the bar, they may be very different to the questions that people have today, and the perceptions that people have today about a career for women at the Chancery Bar. And one of the things that my colleagues and friends said to me is that when they were applying in the last few years, they had been concerned to know what the application process was for getting pupillage, whether there were any problems for women in getting pupillages, or any prejudices or barriers to women. And James is a member of our pupillage committee and knows our procedures inside out. So I'm going to hand over to him now to walk through some of the aspects of our pupillage recruitment procedure.
Thank you, Anna, and hello everyone. And it won't surprise you to know that the answer to Anna's question is no, there are certainly no impediments. Our process proceeds in 3 stages at Wilberforce. First, we have the paper application. One does the application form on Gateway, and then 2 people in Chambers review that, and they review that independently and by reference to objective criteria. They then get together and they compare marks, and the top 36 on the average of those marks get invited to a first round interview. The second stage is that first round interview, where you could expect to be interviewed by a panel of 2 people, and it's a bit of a general chit chat and a bit of discussion about a legal problem question you'll be given shortly in advance of the interview. And of those 36, normally 12, sometimes a few more if we've had a particularly strong year, but normally 12 will be invited back for a second round interview, which is a discussion with 4 members of Chambers and involves a longer and more intense discussion over another and different legal problem. Now, there are 2 things that I should stress about that process. The first is that every single person involved at every single stage has been trained in techniques of fair recruitment. That's a non-negotiable. And the second, and in some ways related point, is that the object of the exercise, as far as we are concerned, is solely and simply to identify the best possible candidates for pupillage, and hence the best possible candidates to be good barristers in future and to really contribute to Chambers. And that means we're not trying in the pupillage process. You hear all these horror stories of people who've gone to interview somewhere and they've been made to feel fools, or asked questions designed to show how clever the interviewers are rather than the interviewees. And that's just absolutely not what our process is about. What we care about is making sure that the people applying have every opportunity to do well and to show us how good they can be. And we try to get the very best we can out of candidates throughout. So from that, perhaps I could give you my top 3 tips for maximising your chances when it comes certainly to getting pupillage at Wilberforce. The first is minis, minis, minis. Load yourself up on as many mini pupillages in our area of law as you can. And that's for 2 reasons. First of all, a big part of the assessment process is working out if you're someone who is interested in our area of law, and that is good evidence that you are. And the second is that what you do on minis, what you see, who you meet, the cases that you get exposed to gives you something to talk about, both on your application form and in interview. So you can say, I want to do commercial chancery work, if that's where you end up, because when I did a mini at Wilberforce or Maitland or Enterprise or wherever you do it, I saw X, Y, and Z. My second top tip is to really, really take your time on the written questions on the application form and to aim to give answers that are as concise and structured as possible. Those questions, they're not just sort of throwaway things to fill in by rote. They are a real opportunity for candidates to stand out. And what's really going to make you stand out is if you can show in your answers that you can communicate like a barrister. And that means identifying what your best points are and expressing them in as few words as possible. So really, really think when you're filling out those questions, have I identified my points discreetly? And am I using any words in answering them that I don't need to do? And my third point is that if you get to an interview, when you get to the interview, have the courage of your convictions in that interview, but don't bluster, because not being sure about something can be a conviction in itself. Now, what do I mean by that? Well, a lot of the problem questions we set, what you'll find, we set a problem and then there were a number of questions, and a lot of the questions within that problem will not have an obvious right answer. So it's not just fine if anything is absolutely right, that when you get into the interview, you're not sure what the right answer is. That's where you should be. Now, some people can come into interview and they can be apologetic about that, and they can shirk from the fact that they're unsure, and they can act as if that's something to be afraid of. Don't, absolutely don't. If your view is that the answer is X rather than Y, but that it's really balanced and there are really good arguments the other way and someone could easily accept those arguments, then own that. Do not be afraid to say that. Never be shy or apologetic in an interview about admitting that you found something difficult or balanced. That's not a problem for a barrister. That's the whole point of barristers, to express views on things that are difficult and where people could think differently. But equally, if you find yourself in a hole in the interview, and goodness knows we all find ourselves in holes from time to time, stop digging. The interviews that go really wrong are the ones where someone takes a view, they get asked a few questions about it, which shows that that view is not supportable. You see the sort of rabbits in the headlight look, but they don't stop digging. And that just means that the interview never goes well. So don't do that. If someone makes a point to you and it's one that you just can't answer, you'll get much, much more credit for acknowledging that and going back to square one than carrying on digging your hole. And again, that's what good barristers do. We all from time to time go into court making a point, which we're not necessarily very sure about, and the judge asks us a few questions and it explodes the point. And what the good barrister has to do is just accept defeat sometimes and go back to square one and go back to a different way of putting the case. So those are my top 3 tips for succeeding in our process, which I hope are helpful. And at this stage, we'd like to open it out to any questions that you guys have that we could maybe address. Marcia, you're on mute if you were talking.
Yeah. Just a couple of points though, James, and I said I would be talking more than I suggested we might. I just have a couple of points. First of all, I think it's important that people are aware that as far as Wilberforce is concerned, and we're not alone in this, we are giving pupillages with a view to giving our pupils a tenancy at the end of it. We're not simply undertaking a training function. The idea is that the tenancy is yours to lose.
Yeah.
And I think that it's very important that you're aware of that. So we will have 2 or 3 pupils. Usually I think we have 2, don't we? But in some circumstances we've had 3. And you're not in competition with each other. We are giving 2 pupillages on the footing that at the end of it, unless something goes wrong, you will join Chambers as a tenant. The other thing that I just wanted James or Anna, I think James, probably you're the right person to deal with this, is to run through very, very quickly what the structure of a typical Wilberforce Chambers pupillage is.
Sure. And on the first of those points, Marcia is absolutely right. We having a pupil is a major investment for Chambers, both financially and in terms of the time that members put into it. And we are not interested in having pupils who we don't think are really good candidates for tenancy. And history shows that we tend to take most pupils on because of the work done at the pupillage application stage. The structure of pupillage, you can expect to sit with somewhere between 4 and 6 supervisors, normally more towards 6. And you'll normally spend 2 months with them, certainly for the first 8 or 9 months of pupillage. The choice of supervisors is designed to expose you to as many different areas of practice as possible. So the clerks do a lot of work in terms of making sure that you've seen people practicing each of those areas, and at times when their practice addresses particular areas you haven't seen. What you do will depend both on the stage of pupillage you're at and what your pupil supervisor has on. So early on in pupillage, often you're doing less live work and more historic work that your supervisor has just to help you learn the ropes. And then as you get more into pupillage, you can expect to be more involved on live cases, and that can get exciting. And you can, when your own work gets put without modification into a skeleton argument for court, that's very exciting. We aim to make a decision after 9 months. That's normally based on the views of the first 4 pupil supervisors. And that means that for the final 3 months of pupillage, if the answer is positive, as it tends to be at Wilberforce, you're free of the pressure of the tenancy decision. And although now that I'm a supervisor, I probably shouldn't say you can relax a bit more, it does mean that you can really focus on your learning and getting ready for the start of practice rather than have to worry about the pressure that everyone feels about the tenancy decision.
Thanks very much, James. And so let's take some questions. I'll start at the bottom. So I should say that if you prefer to ask questions anonymously, there is the function that allows you to do that. Does Wilberforce Chambers sponsor international students for pupillages? Well, I think the answer is that we have quite a generous pupillage award. I'm not aware that we specifically sponsor international students, but James, do you know anything about that?
If the question is asking about sponsoring visas, I know that we have had
asking about sponsoring visas.
Oh, right, okay.
And I know, I'm not up to speed with exactly what the process is, but I know we have had pupils in the past who require visas. So yes, we're able to accommodate that.
Yes, and in fact we did with Jai Wei, didn't we? Yep. Yeah, absolutely, we did. Fine, okay. So Anna said that work can be flexible in commercial chancery work. Is this not the same way in other areas of the bar?
I think the answer is sometimes, but not necessarily. It depends on the area you're talking about. But for example, in a straight commercial set, it's not to say you could not carve out a practice which is flexible, but a lot of, for example, the big commercial sets, you are going to be often on court-based long-running cases where you may be the second, third, fourth junior, and you obviously cannot dictate the court timetable. So if you want to work certain hours or certain days a week, then there is not flexibility in terms of when the court will sit. Whereas if you have you operate in a practice area where you can at times try and focus it more on out of court work, there is a lot more flexibility there in terms of either paperwork, producing opinions, etc., or advising clients in conference when your diary commitments can also be taken into account. Whereas on long-running large trials, that's not going to happen. I would have thought also similarly in areas like family is usually very court-based, criminal, etc. So I can't speak, generally speaking, where you've got more flexibility between written work and court work. That's where the flexibility in lifestyle comes.
And certainly I can say from my personal experience, when I started out in practice in 1989, when I was doing what would be called general common law work, and I did it for quite a long time, I was in court almost every day, all over the country. And there was no flexibility at all because there was so much court work. And I think we need to get real in our acceptance that if you're going to be running a commercial practice or a chancery practice or a commercial chancery practice, you're not going to be in court every day. There may be weeks at a time when you don't see the inside of a courtroom, and that's what gives you the flexibility. And the long trials that come up are, I think, to be fair, few and far between. I mean, you would not expect to have, even as the busiest junior, I would have thought more than 3 or 4 5-day trials in a year. But I may be underestimating that. So the flexibility, in my view, comes from the fact that you're not expected to be in court every day, and you're certainly not going to be expected to be in court up and down the country every day.
I think we're going to have to work up and then start working down because the questions are coming in at the bottom. So
okay,
I think the next one up is offshore work.
Yeah. On offshore work, what does this mean in terms of how the casework changes from onshore work, and what does it typically involve?
Well, from my experience of offshore cases, usually the reason a case is an offshore case is because something about the subject matter of the case is connected to one of the offshore jurisdictions. This happens a lot in trusts, in cases involving trusts which are based offshore, cases where companies are based offshore, such that the proper jurisdiction for the whole dispute is the Caribbean or Bermuda or the Channel Islands or the Isle of Man, for example, largely because of the tax conditions in those places. And so it means that the case at the outset is an offshore case. The reason why they come to English law barristers is because the laws of these jurisdictions derived from English law are extremely similar. There are some differences and they have their own different legislation, but quite a lot of the time the legislation mirrors English legislation with some exceptions. So if there is usually a reasonably large scale offshore dispute, English counsel are often brought in to deal with it. And so that's really how it arises. It's the dispute itself which is always offshore, or some disputes could be UK based, but have spin-off offshore elements. So for example, if they're dealing with a particular aspect of a case where, for example, assets are held by companies in offshore jurisdictions, it might be that that part of the case has to be dealt with offshore because that's the appropriate jurisdiction.
And it used to be the case pre-pandemic that you'd always have to go out there, however short the hearing was. But increasingly now, for the shorter cases, they're done remotely. So apart from having to deal with a terrible time difference, which means that you don't finish in court till 9 o'clock in the evening, our time, that's a lot more convenient than spending 16 hours on a plane for a 2-hour hearing.
Yeah, and I think they take a proportionate approach. So I've just come back from Bermuda because we had a hearing listed for 4 days. And so in that situation, the court is probably going to want you to come out there. But as Marcia says, if it's a half-day hearing, the court may well say all of the barristers in London, there are solicitors working with our local attorneys, and those solicitors are based in London. And so it might make more sense for this shorter hearing, often not dealing with the underlying substance of the dispute, but perhaps dealing with directions, etc., to be held via Zoom or equivalent.
Didn't the Cayman Islands Court of Appeal once sit in chambers?
In our chambers?
In our chambers, yeah. I think for
Probably.
a direction hearing, the Cayman Court of Appeal doesn't sit all the time. The judges are retired English judges, and they're all in London, all the counsel were in London. So they had a courtroom which was the Cayman Islands Court of Appeal for a day.
Fantastic. I didn't know that. I think it's just one more thing before we leave this, because I think it's more of offshore work is more of a feature of a chancery focused practice than a pure commercial practice, because all of those practice areas that Anna identified that tend to take work offshore, so company work, insolvency work, trust work, private client work, those are particular practice areas that are peculiar to chancery work.
Yeah, you get a crossover, I think, as well. But I think exactly it's predominantly chancery work or commercial chancery work. And there is, I mean, I think this is one of the things I was saying earlier, there is a large degree of overlap between the work that a pure commercial set will do and between the commercial work that we will do. It's just that we then also have quite a few other areas that we do as well, which often translate into offshore cases. Another question, would my mini pupillage be disadvantaged if I got BCC for A levels, but with mitigating circumstances?
Should I take that one?
Yeah.
The answer is that alone is certainly not going to disadvantage your mini pupillage application. But let me explain that a bit further. Intellectual ability is a major part of both the mini pupillage and the pupillage assessment stages, and we need evidence of outstanding intellectual ability. But where we normally find that is in degree results, including first, second year exam results. So if your first and second year exam results came up to the level that was required to get a mini pupillage in that session, then the fact that your A-level results were B, C and C with mitigating circumstances would, I think, not feature at all in the assessor's criteria. You sometimes get a situation where you have two candidates with pretty similar degree results, and then you do, in that situation, look back at A-level results. But the reason for doing that is to see if you can identify some trajectory, because you're more interested in someone who's kind of really, got into gear at university and appears to be really improving than someone who's in a stable state. But from the way you describe it, it sounds like you certainly wouldn't be hindered by the A-level results in that assessment.
And just sort of following on from that, we have a question, James. Does Wilberforce allow repeat applications for pupillage?
We do. And we've only started doing that in recent years, so we don't have a huge amount of experience on it. But in the couple of years we've been doing it, we've had a few repeat applicants who've got very far on into the process.
Yeah. And also a related question, which James, you'll know the timetable probably better than me. When are the results of many pupillage applications? That
I think is a week today, so the 28th of June, I think.
a more mini pupillage question. By average, how many people apply for mini pupillages at Wilberforce?
That can really depend. There's kind of no definite set answer, but sometimes it can be, for a session, it can be as few as 20, and sometimes it can be as many as 100. And I've yet to work out the pattern of what determines how many people apply for it.
Okay. Is the pupillage interview process different for transferring solicitors?
The answer is no, it's the same process. The criteria applied are the same as well, but we have an express direction that we take into account experience as a solicitor in judging where the candidate falls by reference to those criteria.
Yeah, and I think it's right that the problem question that you will get set in the round 2 or round 3 interview is a problem that that can be answered by at every level. So we're very much conscious, for example, that some of our candidates will be 3 months or 4 months into their GDL, whereas others will be coming to us with an all singing, all dancing law degree. So the criteria, the question is the same, and the criteria is the same.
We've got, what is the best way to prepare for problem questions and debate questions for pupillage interviews? I would say, and James, I'm sure you'll chip in on this, that it's good to, I don't think I'm giving away any state secrets here, but it's good to mug up a little bit on things like contractual interpretation. Those are classic problem questions, and it will just save you time in your preparation period, because what we do is give a problem question, and there's I think it's 30 minutes in the first round for the interviewee to prepare their answers. So if you've got those rules at your fingertips, you're not going to have to spend time trying to either look them up or remember them. And then you can really focus in on what are all the different arguments I can think of as to how to look at this problem. So, for example, a contractual interpretation problem, you can say, how many different ways can that clause be read? What are all the different meanings that those words could have? Is anything I've been told in the background likely to affect the interpretation? Do I think the background would be taken into account looking at the principles of contractual interpretation? So trying to look at it from as many angles and then marshal your thoughts into producing a structured, coherent way of going through, where you present your thoughts and you present your counter arguments, and then you reach your conclusion on issue 1, and then the same with issue 2. So just having those principles at your fingertips, and so really trying to make sure that you do your provision, if you like, on the real fundamentals of the core academic legal subjects, and then thinking broadly about the problem and focusing the structure of your answer. I don't know if you would add to that, James.
I'd agree with that completely, Anna. And the problem questions emphatically are not tests of legal knowledge. So you don't have to be kind of going and researching your advanced trust module on your LLM if that's what you did. But they do inevitably require an understanding of basic legal principles and the kind of thing that often you can lose sight of the further you get on in your training. So mugging up on those basic principles so that you can spend your preparation time concentrating on the different angles and how you're going to present it, I agree with Anna, is the best way to do things.
So does that answer another question that we've had in? Will the problem question be more legal based or based on logical reasoning? Do I need to brush up on core modules of my LLB?
I would say it's a mix. I would say, yes, it's a good idea to brush up on core legal principles. But equally, if somebody hasn't got the law quite right, but has a really sound logical argument, and can explain why they think that and the reasons for it, then it's not going to be held against them to a great extent that they haven't happened to remember or in the time look up a specific legal rule that means that argument is wrong, as long as if that's put to them, you know, they're able to adjust their thinking. But primarily we're looking at the way people think, the way they organize their thoughts, their arguments.
Yeah. Okay, James, a question for you, I think. Will you be offering more mini pupillage opportunities this year? Or if so, do you have a view on when these would be?
I'm not sure if we've yet set the dates, but what we do invariably is have 2 sessions, end of November, beginning of December. So I'm sure we'll do that again. And then one around Easter, normally late March or early April. And then another one in the summer, normally early July. And although I don't know the exact dates, as I say, I'm sure we'll do the same thing this year.
Thank you. So do we have any more questions? Speak now or forever hold your peace.
I wonder if, and I may be met with a resounding silence on this, but whether there are any questions that people have in terms about the bar generally or the Chancery Bar as a place for women specifically, given the loose title of the talk. And so whether any women applicants have any concerns or queries about anything in practice that may traditionally have been seen as a women's issue, although frankly, I think these issues generally apply to most people nowadays.
Or indeed any, we'd also like to find out whether there is anybody listening who is wavering between Chancery and commercial. And if so, why? So if there is anyone out there who is sitting on the fence, then we, you know, answer anonymously by all means. But we've had questions in.
Yes, excellent.
How has support been for women barristers who are pregnant or need to take maternity leave? Well, Anna, I think this has got your name all over it.
Okay. Well, so I've had, since joining Wilberforce, I've had 2 periods of maternity leave for my 2 children. James will actually probably be able to talk about the actual maternity policy to an extent. But as I understand it, we have a comparatively generous maternity leave policy in Wilberforce compared to the Bar Council recommendations. So there is a minimum requirement for all sets of chambers that the Bar Council has in relation to not just maternity, but parental leave. And then each set of chambers can do an enhanced policy if they want, and we have an enhanced policy. And we're all self-employed. So I think it's fair to say, I don't know of any sets that actually pay members when they go on maternity leave, because we're all individual self-employed practitioners. But the maternity policies usually translate to having rent breaks if you have a room in chambers, and expenses breaks. So money that's being collected in for you for cases you've done prior to your leave, you will get an expenses break on it. So essentially you get to keep more of your money, which really eases any cash flow problems or just general financial problems that ensue from taking a period out where as a self-employed person you're not getting paid. In terms of support, one of the most important things for me coming back from maternity leave was trying to make sure that, having been away for that period, I hadn't been totally forgotten about, and my clerks and colleagues didn't think that I no longer wanted a busy practice or didn't want to be put forward for certain types of cases. Now that changes from person to person, because friends of mine have come back and said, I no longer want to be doing urgent injunctions, for example, because it just doesn't work when I've got a 1.5-year-old at home. And that's taken on board and that's respected. For me personally, I wanted to make sure that the elements of my practice which I enjoyed, which included those sort of things, continued, and there wasn't any perception that because I had had children, I wanted a different type of practice without being asked about it. So the clerks in Wilberforce were really brilliant at having really open conversations with me and finding out exactly what it was I wanted from my practice coming back, because it is such a major life change. And in terms of changing things around the edges to make it work a bit better with children, we're really supportive of that. I think that my experience in Wilberforce has been very positive on that front.
And we certainly encourage a year's maternity leave, don't we? Certainly, I know that with I don't know how long you decided to take, Anna, but I do know with other members of Chambers, 2 juniors that I've worked with, in both cases, they took a year and were encouraged to take a year.
Yeah, I think people can take however long they want. I don't know what our upper limit is, if we even have one. But in the past, I think when I first started at the bar, the quotes unquote norm was to take closer to 6 months. Now I would say there's been a shift, and people, the norm is to take a year or 9 months, or sometimes longer. And so again, that's a personal decision. But whatever the personal decision is taken, it's supported.
And then sort of moving into early years of practice, we have a question. Was it a struggle to get cases at the beginning of your career? General struggles being self-employed, and any particular struggles faced because you are women? Well, I think the starting point is that it comes down to your set and how well run your set of chambers is. Now, in Wilberforce Chambers, like any other well-run and fairly run set of chambers, your clerks will be working with you to build your practice and to manage your practice. And so there are no, and there will be no specific struggles in building a practice or in getting cases because you're a woman. Not just because, you know, your clerks want you to succeed and are there to help you build your practice, but because there are built-in safeguards like a fair allocation of work policy. And certainly in any decent set, it's the juniors who will always be, the very, very junior juniors who will always be the busiest. A constant gripe of mine as a silk in Chambers is that I can never find a junior to lead because they're all terribly busy.
Not just the gripe of yours, Marcia. I think that's the general senior view, is that we need juniors to do the work. I think you know, generally speaking, is it a struggle to get cases at the beginning of your career? And the answer is man or woman. I really think it depends on the set. Wilberforce is a set with a lot of work, and our juniors are extremely busy. Echo what Marcia says about whether there are particular struggles facing you because you're a woman. In terms of not getting cases for that reason, that just you know, rightly hasn't been an issue at all that I've experienced. Being self-employed, I think having children, of course, self-employment and maternity leave, and the fact that when you're employed, you usually get a maternity package, and when you're self-employed, you don't. Well, clearly that is not ideal. But then equally, if you have a busy practice and it's reasonably well paid, then it sort of compensates for periods that you might need to take off for any reason, including maternity leave.
The other very important element in practice building and making sure that everybody has a fair crack at the whip is the allocation of junior work when a silk needs a junior. In Wilberforce Chambers, our silks are not allowed to say, I want Anna for this case. I'm not allowed to choose a junior. Because there are obvious reasons for that. You build up a relationship with a junior, and that you're comfortable working with that junior ends up getting all of your lead work, and to the exclusion of others. So what the system that we have in Chambers is that if I need a junior on a case, I go to the clerks, I tell them about the case, we work out what sort of level of junior I need, and the clerks will then look at availability, look at CVs, and send a range of options. So I'm treated like a client when it comes to looking like a junior, and that is very important, because what you don't get is this sort of disproportionately successful junior getting a disproportionately large number of good cases simply because the silk in question has them as their favourite.
James, you can probably be well placed to take the question. If I start pupillage at a commercial chancery set and after a few years want to do predominantly pure commercial work, contractual disputes, civil fraud, arbitration, is that a real possibility?
Well, and the answer, I think experience shows yes. There are a number of juniors in Chambers who have specialised in precisely those kind of disputes, having started out with more general chancery practices. I suppose the one caveat I should put on that is that if you want to do something really specialised within commercial work, like if you wanted to be a pure banking lawyer, for example, well, good luck. But that would be much harder to do from a set like ours, because that kind of very specialist stuff we have less of. But the kind of things in the question, contractual disputes, civil fraud, arbitration, as I say, there are juniors in Chambers who specialise in that.
Yeah, and you can do it exclusively. I mean, we have specialist silks who are exclusively in commercial practice area, and the types of disputes that they and the juniors in commercial are involved in are the same as those in the big commercial sets. They're up against them all the time. They're on fused teams with them all the time. So if commercial is your passion, there is definitely space to carve that out in a good commercial chancery set.
And then we have a question: what is the difference between civil and chancery work? Well, there's no hard difference. Chancery work is an area of civil work. Civil work is an umbrella term that covers all areas of law that are not crime. So civil work will cover family work, it'll cover chancery work, it'll cover commercial work, it'll cover personal injury, it'll cover defamation. So basically civil work is everything that isn't crime, and chancery work is civil work.
Other than academics, how can you evidence your intellectual ability?
Well, academics is the big thing. That's the major way of doing it. But there are others, and there are two others in particular that occurred to me. The first is one I alluded to very briefly earlier with the question about transferring solicitors. There are some people who are moving from a different career or who've done different things while a student, and that experience evidences academic ability. So if someone has done well in a previous career, that in itself is evidence of intellectual ability. The second thing is the answers to the written questions on the application form. Again, that's a chance for you to show in the way you express yourself and the points you come up with that you have outstanding intellectual ability.
I think also I would add to that, if you've done extremely well in a mooting competition, and one of the recognised mooting competitions, I would really encourage everyone to get involved in mooting, because it's such a great skill to hone for your advocacy, but also for your interview technique, because if you're used to mooting, the way you're going to present your answers is probably going to be crisper. And also there are essay competitions, etc., etc. So if for whatever reason you've had a bad couple of exams, but you've got these additional things that can really show someone looking at your application that your intellectual ability is really up there, then those are great to put yourselves forward for and to definitely put down on your application.
Then do barristers have the opportunity to work with some clients over years in the way solicitors, and just as not in the way I think solicitors do, not just as one-offs? The answer to that is sometimes yes, depending on your practice area. So, for example, I'm an insolvency and restructuring specialist, which means that a lot of my clients are accountants and insolvency practitioners. So there are other professionals who have taken on jobs as liquidators, receivers, trustees in bankruptcy, and administrators. So I will get a lot of repeat business from those clients across different firms of solicitors. Anna, James, any other observations on that?
I think if we're talking about lay clients, often you can have cases that go on for years and years. So you do have an ongoing relationship with the lay clients. In long running cases, there are often spin-off disputes, there are appeals. So if they're continuing to instruct the same solicitor and it's a dispute that's falling in your practice area, then you may well end up with repeat business from the same lay client. Obviously, most clients don't want to be involved in a lot of litigation, and so their ideal is probably to only see you just for one case. But if they've got multiple cases going on and it's in your practice area, then there's no reason why you wouldn't get repeat business from them. And then, of course, the solicitors themselves are the clients who you have your main relationship with, and that's definitely the key to a good practice, is building your relationships with your professional clients, your solicitors, who you get to know very well and who you can work with throughout your careers often.
The thing I would add to that as well is that property work, I think, brings an awful lot of repeat lay client business, because you get lay clients who get involved in a lot of litigation. So that can be institutional landlords who own tens, hundreds, thousands of properties across the country. You get property developers who are always getting in spats about development sites. You get house builders, again, often in litigation. And then you can get clients like utility companies. I've got a number of utility companies who instruct me a bit, who've got large amounts of properties and therefore end up in a lot of disputes.
Could you explain the clerk system? How are the clerks regulated, for example?
That's quite a long answer. Let's start with the second part of the question. Are clerks regulated? They're not regulated. They have their own professional body, the Institute of Barristers Clerks, the IBC. So it's their sort of trade association. A lot of clerks have an element of sort of professional training, like MBAs and things like that. But at its core, it is an unregulated profession. At its most basic, the clerking team is a team of agents. They manage your practice, they negotiate your fees. And at the beginning, certainly when you start out, your clerk is instrumental in getting you your cases in your early days until you've built up your own practice. And even then, clerks are responsible for allocating work. So if a piece of work comes into Chambers that is not allocated, the clerk will decide a short list of 4 or 5 barristers who would be the most appropriate to get that job, and give that short list to solicitors. As I said, they negotiate your fees. They are responsible for collecting in your fees. They are pivotal in helping develop your practice. Having said all of that, most chambers now have a sort of split business model where you have a pure clerking team, as we do, and you have a chambers director team, which is essentially responsible for sort of bigger picture stuff, marketing, business development for chambers, that sort of thing. Do you think that's a fair summary, James, Anna, on a big topic?
Yeah, and I just the one thing maybe to add about regulation is something Marcia's referred to already, which is that we internally to chambers we have the fair allocation of work system.
Yeah.
So the way in which clerks deal with opportunities in chambers is monitored. And were there any concerns? And I'm not aware of there having been any, but were there any concerns that it could be addressed in that way?
Yeah, and they all have appraisals, reviews by peers, by barristers. So there is certainly accountability in respect of clerks as well.
One final question, because we can take this one very shortly. Is mediation and arbitration a part of Wilberforce's portfolio? Well, we have an arbitration team. And essentially arbitration isn't a magic word in the sense that it is not a practice area of its own, although we have an arbitration team. It's a particular feature of commercial work, but you do get it in property work, you get it in insolvency work, you get it in professional negligence work. So the answer to that is yes, it's part of our portfolio. Mediation, well, we all involved in mediations. I doubt that there is anybody in chambers who has not done a mediation. I probably participate in at least 2 mediations every year, and it's a hugely important part of any barrister's practice, especially since there's all this muttering at the moment about compulsory ADR in particular areas of practice. We also have quite a few members of chambers who are qualified mediators. So we've slightly overrun, but thank you very, very much. We're going to have to wrap up now. Thank you all of you for participating, and thank you very much for your excellent questions. We really hope that this has been a helpful session for you.